works anyway.
Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare a recess at any time. Pursuant to notice, I now call up H.R. 3808 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 3808, to preclude absolute liability in any action against a property owner or contractor for projects receiving federal financial assistance for infrastructure and transportation development and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. I commend Representative John Faso from New York for introducing H.R. 3808, the Infrastructure Expansion Act, a common-sense piece of liability reform tied to federal funding in the context of federal infrastructure and housing programs. This bill, if enacted, would save billions of dollars in federal taxpayer money and facilitate the construction of much-needed infrastructure and housing projects. Currently, New York is the only state that allows absolute liability against property owners and contractors for injuries sustained by construction workers through their own fault, including intoxication and failure to use provided safety equipment. That New York law, a statute referred to as the scaffold law, was originally enacted in 1885 when skyscrapers were first being built and no other worker safety regulations existed. Under that law, one category of injured workers, those who suffer gravity-related accidents, get the benefit of absolute liability not only against the worker's employer, who is today already liable under workers' compensation, but also against parties who often have little to no supervisory control over the project, such as property owners and general contractors. Absolute liability is imposed on these third parties with no limits on damages and no consideration of fault or of the disregard of instructions by the worker. Because the scaffold law imposes such costly liability on those involved with federal infrastructure projects in New York, the costs of federally funded projects that go through New York have soared, and these costs are passed on to federal taxpayers and the construction industry generally. According to a 2013 study conducted by the Rockefeller Institute of Government, a public policy research arm of the State University of New York taxpayers spend $785 million annually for the insurance costs associated with public construction projects due to the scaffold law. The financial cost of the scaffold law is so large that the added cost of insurance in New York can tip the scales against a project altogether. For example, insurance costs associated with the scaffold law were so high that several disaster relief organizations gave up on helping New York families affected by Superstorm Sandy, choosing instead to help those in neighboring states. Habitat for Humanity of New York supports this legislation, saying in a letter to the editor of a New York paper that, quote, Habitat for Humanity and our volunteer partners strive to create a safe environment for our staff, contractors, and volunteers. The scaffold law has hindered our efforts to build in New York and should be reformed. The Times Union editorial board should support Congressman John Faso's effort and the efforts of state legislators on behalf of worker safety, on behalf of civil justice, and on behalf of all New Yorkers who struggle to find affordable housing, end quote. In 2014, Habitat for Humanity New York City wrote that, quote, many of our fellow nonprofit recovery organizations have struggled to obtain necessary insurance coverage due to the availability of crisis driven by the scaffold law. Make no mistake, the scaffold law has directly and significantly hindered organizations' ability to help hundreds of New Yorkers return home after Superstorm Sandy, end quote. H.R. 3808 would apply only where federal funds were used on an infrastructure project. In such cases, the bill would apply a comparative negligence liability standard to gravity-related injuries that occurred on such projects, a standard that considers the comparative negligence of the injured person when such negligence is a proximate cause of an injury to a person. Today, every state uses some form of comparative or contributory negligence liability in tort cases generally. I will offer a manager's amendment that will also allow courts to use a contributory negligence standard, thereby preserving all state law in this context and overriding only New York's particular scaffold law and only when federal funds are involved. I urge all my colleagues to join me in supporting this simple and fair reform legislation that will facilitate federal infrastructure projects, expand housing for the homeless, and save billions of dollars in federal taxpayer money. It's now my pleasure to recognize the ranking member of the committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 3808, the so-called Infrastructure Expansion Act of 2017, has nothing to do with improving infrastructure, but is rather a bald-faced attempt to undermine enforcement of a New York State law that protects workers at construction sites. This law, known as the scaffold law, imposes absolute liability on the property owners and general contractors at construction sites for elevation or gravity-related injuries if they fail to provide a safe working environment. Only if they fail to provide a safe working environment. The scaffold law has long been the subject of vigorous debate in New York. There have been repeated attempts in the state legislature to repeal or modify the law. But there is no excuse for Congress doing an end run around this process and for taking up this legislation, particularly in the complete absence of hearings or legislative process. For these reasons, I must oppose this bill. H.R. 3808 effectively prohibits application of the scaffold law when plaintiffs bring a case seeking damages for injuries suffered while working on a construction project that directly or indirectly receives federal financial assistance, terms that the bill does not define and that potentially are broad enough to encompass most construction projects. The bill requires that any lawsuits alleging injury under such circumstances must allow for consideration of the plaintiff's comparative negligence, accordingly reducing or eliminating any damages that the defendant must pay. The scaffold law, first enacted in 1885 by the New York legislature in response to its concern over unsafe working conditions involving heights, provides that all building contractors and owners and their agents must put in place a variety of safety measures to protect workers at a construction site. In 1948, the New York Court of Appeals, the state's highest court, interpreted the scaffold law to impose absolute liability when an employer, contractor, or property owner fails to provide proper scaffolding or other elevation-related equipment at a construction site, and such failure was the proximate cause of the plaintiff's injury. The court reasoned that the legislature, in passing the scaffold law, absolutely imposed a flat and unvarying duty on employers, contractors, and property owners to give proper protection to workers because they were in the best position. The employers were in the best position to protect workers from faulty or inadequate equipment. In every session of the New York legislature, going back at least since I was a member in the 1980s and probably further, bills have been introduced to amend, repeal, or modify the scaffold law and its qualified strict liability enforcement regime. Each time the legislature chose not to act on these bills. But supporters of this bill want to take the decision out of the hands of New Yorkers and place it into the hands of Congress. And they want to rush it through the legislative process without even demonstrating the need for it or understanding its potential consequences. Opponents of the scaffold law argue that it is outdated and out of step with the rest of the country. They also argue that New York's law inhibits infrastructure investment in the economy by increasing construction costs because of high insurance premiums. Supporters of the law, on the other hand, believe it's a critical safety measure that protects workers. Whatever the merits of maintaining, amending, or repealing New York's scaffold law might be, however, the key point is that this is a decision for the state of New York and not for Congress to make. Tort law has always been a matter left to the states. It is sheer arrogance to think that New York cannot govern itself and that Congress knows best in this instance. H.R. 3808 represents a deep intrusion into state sovereignty, and it is especially troubling because it targets just one particular state's law. For all the foregoing reasons, I must oppose this bill. Before I close, I must make a separate but urgent request. We have reached an inflection point in our politics, Mr. Chairman. For months, my colleagues and I have urged this committee to conduct meaningful oversight of the Trump administration. Across the board, House Republicans have failed in that responsibility. Despite the intelligence community's unanimous conclusion that our last election was compromised by a foreign adversary, and their warning that Russia and others will certainly attempt to compromise our next elections, they have taken no action to secure our next election from foreign adversaries. The majority seems not to care that President Trump has tried to pressure all three of his FBI directors to make the Russia investigation go away. The majority took the time to trash Deputy Director McCabe in a letter last night, but said nothing about the president's attempt to fire Special Counsel Mueller, or the president's hints at removing Deputy Attorney General Rosenstein, or the president's months-long personal attack on Mr. and Mrs. McCabe. But before now, we can only say that the House Republicans had ignored an obvious, coordinated attempt by President to protect President Trump by undermining the special counsel and the FBI. Over the past few days, Mr. Chairman, that characterization has clearly changed. Last night, the Intelligence Committee voted to release a so-called Nunes memo, a set of talking points written by Republican committee staff and based on highly classified information related to an ongoing investigation. They did so over the objection of the Department of Justice, without regard for obvious national security concerns, and without having read many of the documents that the Nunes memo purports to summarize. So House Republicans are no longer simply ignoring an obvious attempt to obstruct the work of the special counsel. House Republicans are now complicit in an obvious attempt to obstruct the work of the special counsel. They are accessories to it. Earlier this month, at your request, Mr. Chairman, the Department of Justice allowed the two of us to review many of the materials that would put the Nunes memo into context. As far as I can tell, you and I are among the very few members who have actually read these source documents. I should add, Mr. Chairman, that your December 6th letter asking the Department to provide us with these documents cuts against most of your earlier explanations for inaction. You can ask the committee to wait until the special counsel has finished his work before we talk about Russia, or you can assert our jurisdiction to obtain these documents, but you cannot consistently do both. You asked for these documents, the Department delivered, and the investigation into connections between the Trump campaign and the Russian government are now fair game for hearings and further discussion in this chamber. Because these documents are critical to understanding many of the gross inaccuracies of the Nunes memo, and because so many members of this committee have openly characterized that classified memo in the press, without any firsthand knowledge of the documents on which that memo is supposedly based, it is imperative that every member of our committee have access to this material without delay. I wrote to you last week to ask you to work with me to secure that access. I want to make that case again to you now, but I cannot do so in an open setting. I therefore move that the committee immediately move into executive session for further discussion of this topic. If we need to move into a classified setting after that discussion, we can take that step as well. Mr. Chairman, I made the motion that the committee immediately move into executive session for further discussion of this topic.
The gentleman should put his motion in writing.
I will certainly. It's being delivered to the desk right now. It's at the desk.
The clerk will report the motion.
Motion to close committee proceedings offered by Ranking Member Nadler. I do hereby move that the committee now go to executive session because disclosure of matters to be considered would endanger national security or would compromise sensitive law enforcement information.
So the chair recognizes himself in opposition to the motion. We have before the committee today matters related to a bill that was properly noticed before the committee, and the committee should adhere to the agenda of the committee and should not engage in this type of effort to bring up something that is not before the committee and which has not been noticed to the committee, and I think it is inappropriate to have an executive session at this time.
Mr. Chairman.
First gentleman from New York, seek recognition.
Mr. Chairman, we have been attempting to get a discussion of these matters before this committee for, almost a year. We have written repeated letters to you. We have spoken repeatedly. We have asked for full committee access to the FISA materials that you and I have reviewed. We've asked to discuss the interference with the FBI and the special counsel by the President and others. We've asked to discuss the circumstances surrounding the firing of James Comey. We've asked to discuss the foreign interference in federal elections. We've asked to discuss the many apparent ethics violations of the administration, including the President's violation of the Foreign Emoluments Clause of the Constitution. In every case, the committee has not acted. The chairman has stated repeatedly that we didn't have to act on any of this because the special prosecutor was doing the investigation. This despite the fact that the special counsel actually is limited in his jurisdiction to looking at crimes, while we have the jurisdiction to look at the circumstances and to look at the effects on the country and on the Constitution. We have been stonewalled. We have this memo now from Mr. Nunes, based allegedly on underlying documents, which I can say, having read the underlying documents, it's totally misleading. We have the release by the Intelligence Committee of that document. We have other matters, and ample reason that this committee must get involved. And this committee now, or at least the Republican members of this committee, have been alleging various conspiracies and other plots. And I make this motion now, and we can discuss in executive session all the details and why, because we have been asking for a long time for this committee to take action, or at least to discuss these matters, which are in our jurisdiction. The FBI is subject to systematic attack by the administration. The FBI is within our jurisdiction, not the Intel Committee's jurisdiction or anybody else. The Department of Justice is within our jurisdiction, and I would submit that it is our duty to look at the circumstances under which the integrity of the FBI is being maligned and its integrity assaulted. There is a very serious issue before this country as to the integrity of our public security agencies, and we have to get into that. And I make this motion now to go into executive session to discuss this, because we have tried every other means to do so. And frankly, this is more important than the scaffolding law, as important as that may be on either side.
Mr. Chairman?
Mr. Chairman?
Would the gentleman yield?
I'll yield.
I thank the gentleman for yielding. Well, first of all, as the gentleman knows, we have recognized in this committee that there is a special counsel. I have always supported the work of the special counsel, have never called for the termination of that work, and believe that that work should continue. And we have not a special counsel appointed to delve into the matters related to the other side of the congressional campaign, the campaign of Hillary Clinton, and many concerning matters related to the behavior of the former FBI director and many other people in the FBI and some in the Department of Justice during that time frame. And so we launched, with the cooperation of the gentleman from South Carolina, the chairman of the Oversight and Government Reform Committee, a examination of that. We have so far interviewed 2 witnesses. We have examined a number of documents. And we have, as the gentleman knows, adhered to, in those confidential but not classified interviews, a rule that we would stay away from the matters related to Trump-Russia, and we would examine the matters related to other things. Now, there's no question that other committees in the Congress, including the House Intelligence Committee, are doing work that is very much related to what the gentleman is interested in this committee looking into. But I am completely satisfied, and I think members on my side of the aisle are satisfied, to allow the special counsel to do the work that the special counsel is doing and see what the special counsel report. We do have an oversight responsibility. Your predecessor and I have met with the Mr. Mueller himself, with the deputy FBI director, and certainly if we have future meetings in a confidential or classified setting to do that, you would, of course, be included in that as well, because we do have a responsibility to make sure that this is a fair and impartial investigation, but we are not going to get into the underlying substance of that investigation. So I'm opposed to the gentleman's motion because I think it is directed in that direction. It's directed to try to counter efforts going on in other committees of the Congress, which I am not engaged in, except that I may be consulted by others in other committees. That is very different than this committee launching an investigation, and for that reason, I must oppose the amendment.
Reclaiming my time for just a moment, I would simply point out that regardless of, or without contradicting, without getting into the debate of what the chairman just said, it is clear at this point that the FBI has been subjected to attack. Mr. Comey was fired. Mr. McCabe has now been forced out. Mr. Rosenstein has been subject to criticism from on high. it is clear that everybody associated with the investigation or who supervises it, even the Attorney General has been criticized because of this publicly and humiliated publicly. There is a concerted attack going on against the integrity of the FBI and of the investigation, and that this committee cannot fob off on a different committee. That this committee must look into, and that's part of what we're talking about today. I will, in a moment, I will insist on the motion, but some other members want to.
For
Mr.
the
Chairman,
purpose of the gentleman from Iowa seek recognition.
Mr. Chairman, I move to table the motion to close committee proceedings.
The motion has been made to table the
Mr.
motion of
Chairman?
the gentleman from New York.
Mr.
All
Chairman?
those in favor of the motion respond
Mr.
by saying
Chairman?
aye. Those opposed, no.
No.
Chair, the ayes have it, and the
Yes, for
motion to
record
table
vote.
is agreed to. Record vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Isa? Mr. King? Mr. King votes aye. Mr. Gomert? Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Poe votes yes. Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Gowdy votes yes. Mr. Labrador? Mr. Labrador votes yes. Mr. Farenthold? Mr. Farenthold votes yes. Mr. Collins? Mr. DeSantis? Mr. DeSantis votes yes. Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Gates votes yes. Mr. Johnson of Louisiana? Mr. Johnson votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. Rutherford? Mr. Rutherford votes aye. Ms. Handel? Ms. Handel votes aye. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Johnson votes no. Mr. Deutsch? Mr. Deutsch votes no. Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Mr. Schneider? Mr. Schneider votes no. Ms. Demmings?
The gentleman from Texas, Mr. Gomer.
Mr. Gomert votes yes.
Has every member voted who wishes to vote? For purpose, gentleman from New York seek recognition.
Am I recorded?
Gentleman is recorded as a no vote.
That's my motion right here.
The clerk will report.
Mr. Chairman, 16 members voted aye, 12 members voted no.
And the motion to table is agreed to.
Mr. Chairman?
Chairman,
The,
parliamentary inquiry, Mr. Chairman.
the chair now recognizes the chairman of the Subcommittee on the Constitution and Civil Justice, Mr. King of Iowa, for his opening statement on the legislation before the committee.
Thank you, Mr. Chairman. Mr. Chairman, I join you, Chairman Goodlatte, and a good many other members in supporting this necessary reform that will facilitate federal infrastructure projects, expand housing for the homeless, and save billions of dollars in federal taxpayer money. Legal reform is a vital component of the administration's infrastructure plan, and this bill will deliver it for the American people. Philip Howard, the chairman of the bipartisan legal reform group Common Good, wrote the following about this bill in the New York Daily News, and I quote, "New York is at the cusp of a major infrastructure building boom, but an obsolete New York statute from the 19th century called the Scaffold Law has already wasted $200 million on one project. The new Mario Cuomo Tappan Zee Bridge, with the $25 billion Gateway Rail Tunnel project under the Hudson River potentially nearing approval, it's vital that the scaffold law be repealed in order to avoid wasting as much as $300 million on that project alone. That's the Port Authority's estimate, which is part of a fuller analysis of the scaffold law recently released by Common Good, the nonprofit group I chair. Overriding the scaffold law should be the first step in a larger legislative effort to repeal obsolete laws that cause waste in infrastructure projects. Over many years, I continue to quote, the New York State Legislature has resisted all efforts to eliminate the scaffold law, which is a favorite of trial lawyers because it creates absolute liability with no limits on damages for many construction injuries. Construction workers are already covered by workers' compensation with their employer, but the scaffold law imposes unlimited liability on property owners and others who have little or sometimes no supervisory authority. In 2012, 16 of the 30 largest settlements in New York involved the scaffold law. Largely as a result, New York's general liability insurance costs for construction are the highest among the 50 states. In Congress, John Faso introduced a bill that would prohibit application of the scaffold law to any projects receiving federal funding. New Yorkers should rally behind that measure, which will reap immediate savings. It's time for taxpayers to let their elected officials in Congress know that they don't want to pay for the waste from obsolete laws, close quote. Well, the Rockefeller Institute also compared the construction worker injury rate in New York with that of Illinois after Illinois repealed its own version of the scaffold law in 1995 and found that New York's scaffold law encouraged more injuries, presumably because workers are incentivized to engage in more personal responsibility when they cannot blame others for their own negligence. And so it appears New York's scaffold law not only makes infrastructure projects more expensive, it also seems to encourage more injuries. H.R. 3808 is based on the policy that federal taxpayers shouldn't have to pay for the uniquely limitless liability New York scaffold law imposes on property owners and on general contractors involved in federally funded infrastructure projects in New York. New York has a right to enact its own laws governing the people of New York and its state taxpayers, but Congress has the clear constitutional authority to break down such barriers to national infrastructure projects when federal taxpayer money is involved. And I would point out, in addition, that we're going to hear a State of the Union address tonight. I'm very confident that the President is going to bring up his infrastructure initiative, and it's also a fact that the President is from the state of New York, and I'm very well confident that he is well-versed with the existing scaffold law, and he would eagerly like to see this arrive at his desk. Our timing is good. The cause is good. I congratulate Congressman Faso for bringing this before this committee. I thank the chairman, and I urge its adoption. Yield back the balance of my time.
Thank you, Mr. King. I now like to recognize the ranking
Chairman,
member of the
parliamentary
subcommittee.
inquiry, please.
The gentleman will state his parliamentary inquiry.
Mr. Chairman, can this House Judiciary Committee, by unanimous consent, agree to bring up legislation to finally protect the special counsel from the ongoing efforts on the part of the leadership of the House Intelligence Committee and the White House to sow discord and confusion and distraction and threaten the very investigation that the President tried to end in June when he ordered that the special counsel be filed? Can this committee, by unanimous consent, agree to bring up that legislation?
I think that the gentleman should follow the proper rules and procedure and notice requirements, but there is no unanimous consent for what the gentleman suggests. So the committee will resume. The parliamentary inquiry has been addressed.
Mr. Chairman, it has not been addressed. I would like the chairman to simply answer this parliamentary inquiry. Can this committee, by unanimous consent, agree to take up those bills?
It would violate House rules.
Point of order, Mr.
If the chairman would elaborate on those House rules, it would be violated.
There's a 24-hour notice requirement to bring the legislation.
I understand, Mr. Chairman. Can that be waived by unanimous consent?
It's a House rule.
Or can it be waived with the concurrence of the chairman?
No, not without the concurrence of the House. It's a House rule. The gentleman's inquiry is academic, however, because there is not unanimous consent
Well,
for
We haven't
no, no,
asked.
no,
the
Mr.
type of motion
Chairman.
the gentleman just suggested he wanted to bring up.
Mr. Chairman. No, no, Mr. Let me, if I
I
may,
will
Mr.
now
Chairman.
recognize the ranking member of the Subcommittee on the
Chairman,
Constitution
you
and
did
Civil
not
Justice,
answer the
Mr. Cohen of Tennessee, for his opening statement.
Thank you. Firstly, I'd like to say some of us attended a hearing in New York about the Grammys, and I want to reflect on my friend Warren Zevon's Grammy in 2003 for the song Disorder in the House. To the land of the home of the free and the land of the brave, where the less you know, the better off you'll be. With that homage, I go on to my statement. This bill, H.R. 3808, has nothing to do with expanding infrastructure or bolstering our economy. It has nothing to do with people on scaffolds taking higher risks so they can get better judgments from a court and risking their lives 50 stories above the ground. That's ludicrous. Hold that up, please. These people, men and women that get up on scaffolds, don't do daring stunts to get money through trial lawyers. That is baloney. This is aimed at overturning the absolute or strict liability regime of the state of New York's labor law, known as the scaffold law. Under that statute, contractors and owners on construction projects have an absolute duty to provide safe scaffolding, ladders, hoists, or other elevation equipment. It prohibits any absolute liability lawsuit, this bill does, based on a claim for injury stemming from the failure to provide such equipment for any project that directly or indirectly receives federal financial assistance. That's ludicrous. Would you want to get up there? Would this be a safe place to work? Wouldn't you want the best rules and the best laws and the best sureties that you could have to say that you wouldn't lose your life and your family wouldn't lose their breadwinner? I think you would, and New York does too. New York courts have interpreted the scaffold law to impose absolute liability, but only when a contractor owner has failed to provide proper and safe equipment, and that failure was the proximate cause of the worker's injury. That makes sense. That's family values. The ultimate goal of imposing such modified absolute liability on contractors and owners is to ensure that those who are best positioned to guarantee workplace safety take the greatest care to do so. Not builders who build large buildings or casinos in cities and don't care about their workers and only care about greed and profit. The facts arising from recent scaffold law-related litigation demonstrates the prevalence of elevation-related injuries, particularly in New York City, and the continuing need for the scaffold law. For instance, in June 2017, a construction worker in Brooklyn died after falling from scaffolding. A supervisor blamed the man's fall on a slip, but the fire department of New York requested an inspection after finding a loose scaffold shortly after the accident. That same month, 6 construction workers in Queens received non-life-threatening injuries in a scaffold collapse. In September 2017, 2 workers at 2 separate construction sites in Manhattan died from falls. And in October 2017, 2 workers were seriously injured at a Bronx construction site after falling 20 feet as a result of shoddy scaffolding. As these recent incidents demonstrate, there's ample reason why the New York legislature would want to keep the scaffold law to protect the citizens of New York who get up on these scaffolds and do the work to build all those skyscrapers that we all saw when we were in New York. They're everywhere, and somebody's got to build them and risk their lives. As these recent incidents demonstrate, there's ample reason why the New York legislature want to keep the scaffold law and a strict regime in place despite numerous attempts to weaken that for greed, for money for the developer. Given the particularly large amounts of high-rise building construction that takes place in New York and New York City in particular, it makes sense the legislature would want to respond to particularly heightened local dangers and risks by enacting particularly strict workplace safety mechanisms. Notwithstanding the New York construction industry's well-documented risk of elevation or gravity-related risk, a coalition of property developers, people who can make big campaign contributions, contractors, and tort reform groups support H.R. 3808 on the grounds that the scaffold law increases insurance premiums and infrastructure costs. Yet such assertions are unsupported by any publicly available data that can be scrutinized. H.R. 3808 attempts to impose a one-size-fits-all standard that ignores local conditions. These defects that defeats the whole point of having a federal system where states are responsible for much of the health and safety laws to protect workers and others precisely because conditions vary from state to state. New York is where they build big buildings on broad shoulders, and they don't want those people with broad shoulders to fall down on their rears, and we shouldn't allow it. We need to be a safety net. Because H.R. 3808 inappropriately circumvents the New York legislature's determination that an absolute liability regime is the best approach enforcing the duty of contractors and owners to ensure workplace safety. And because this bill hasn't even had a hearing, not even a hearing, I strongly oppose this bill and urge the community to this committee to reject it, go back to regular order, have hearings, have facts established, and then vote on what is the best thing for state-federal relations and for workers. I yield back the balance of my time.
For what purpose the gentleman from Rhode Island seek recognition?
Mr. Chairman, I would ask the committee, motion to strike last, move to strike last word, and I have a motion at the desk.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I'm asking the committee to
You want us
take...
to report the
Yes.
motion? The
Sorry.
clerk will report the motion.
Motion to move into classified setting offered by Mr. Cicilline of Rhode Island. I do hereby move that the committee moved into a classified setting because disclosure of matter to be considered would endanger national security by revealing highly sensitive intelligence, asset, and source materials, and would compromise sensitive law enforcement investigations.
Thank you, Mr. Chairman. I'm asking the committee to take
Gentleman is recognized for 5 minutes.
a temporary reprieve from overruling the duly elected decisions of the people of New York by considering a bill to enrich wealthy New York developers at the expense of working people to consider my motion. And I thank the ranking member for an earlier motion to move us into executive committee. This motion is to request that we move into a classified setting so we can address many of the issues that have been raised. The notion that we are too busy to do this or we haven't raised this sufficiently is nonsense. We have written to the chairman of this committee time and time again, imploring him to take up the responsibilities of oversight by this committee, to address the issues of the ongoing attack on the FBI, the Department of Justice, an ongoing effort to undermine the credibility of the investigation and the integrity of Robert Mueller, and the American people's demand to know the truth. Those calls have gone unanswered. We now see a new effort underway with the compilation of a so-called report by a person so partisan that he was removed from leading the investigation. That is, we know now that there is information that the disclosure of that report was occasioned in part by a campaign online, released the memo with significant Russian participation. So the responsibility we have to provide really meaningful oversight while this FBI is under such sustained attack. We see the firing of the FBI Director Comey, driving out of Andrew McCabe, undermining of Mr. Rosenstein, and the list goes on and on. This is the committee, and the chairman is quite right. Many other committees are doing their work. They're doing their oversight, fulfilling their oversight responsibilities. We do nothing. We remain silent. What we're asking is to go into a classified setting to give us the opportunity to make the case to you, to the other members on the other side of the aisle. Now, you'll make a motion to table, and you will deny every member of this committee the opportunity to be heard on this motion. You'll pat yourselves on the back, very proud of that, and you will have disrespected the demands of the American people to know the truth, and for the members of this committee to fulfill the responsibilities when we took the oath of office, to provide meaningful oversight over the Department of Justice and the FBI, and to safeguard the integrity of this ongoing and serious investigation. And so I am asking the members of this committee, when you make the motion to table, to vote against it, to respect the American people enough to go into executive session and face us, face to face, make your arguments. If you're so proud of your effort to enable and aid and abet in the cover-up by this administration, then be willing to say it in public.
Will the gentleman yield?
No, I won't. Say it in public.
Trying.
And be part of the debate. And vote to go into an executive session or closed session and have this debate with us. And respect the American people enough to know they demand to know the truth, and don't continue in this ongoing effort to prevent real oversight by this committee. And I'll yield the balance of my time to the gentleman from California, Mr. Swalwell.
Thank you, Mr.
To offer
Chairman.
the motion.
I thank the gentleman from Rhode Island for his motion. This is the House Judiciary Committee. It's a privilege for all of us to sit on this committee. And at this dark hour in our country, Mr. Chairman, we are considering laws with respect to scaffolding. Now, we should be talking about scaffolding, but the scaffolding of our democracy, because it is under attack by a wrecking ball, not just from the Trump administration, not just from the president anymore, but by his allies in Congress. Tonight, he'll address the House and the Senate and the American people. And the state of our union, Mr. Chairman, is lawless. It was lawless when the president tried to fire and did fire James Comey. It was lawless when he put pressure on Jeff Sessions to fire Andrew McCabe, and it is lawless as he continues to use his allies in Congress to undermine and fire Bob Mueller. If there ever was a time when the Judiciary Committee should set aside its ordinary business, it is at this very, very troubling time for our democracy. And I would hope that we could go into a classified setting and discuss the Democratic memo that every single Republican on the House Intelligence Committee refused to allow the public to see. A 10-page memo that rebukes and shines light on the memo the Republicans have put out as a brainwashing effort to the public. It rebukes it, and not only rebukes it, it provides a mountain of new evidence that provides more and more credibility for the investigation the FBI is conducting. So I second the gentleman's motion, and I hope all of my colleagues will move to go into classified section at this important time for our country. I yield back.
For the purpose of the gentleman from Texas, Mr. Gomer, to take recognition.
Strike last word.
Gentleman's recognized for 5 minutes.
I have not long ago watched the Watergate hearings and have been struck by the concern about liberty and about this little experiment as a democratic republic, that Republicans took an active interest in pursuing what the Nixon administration had done. We have now come into evidence that not only was the IRS weaponized, we weren't able to do much about it because our friends across the aisle were stopping us at every turn. We now have evidence that the DOJ and our intelligence agencies have been weaponized, and that the DOJ and some intelligence assets combined with a political campaign to surveil a presidential candidate from the opposing party, and even after he was elected, to potentially even bring down his presidency. My friends across the aisle have been very loud this morning. We're just trying to debate over a bill so that the federal government doesn't end up being screwed over for money that could go to help children, perhaps with health insurance. But my friends are going to be on the wrong side of history if we have history 40, 50 years from now as a democratic republic. And people like us are looking back and seeing that the Republican elected representatives wanted to find out and get to the bottom of how deep the weaponization went and root it out and try to make sure that nothing like that would happen for another 40 or 50 years. And this other party was doing everything they could to prevent us getting to the bottom of just how disastrous this constitutional crisis had become. It's not going to look good. And my friends, when others 40, 50 years from now are seeing the tapes and seeing the righteous indignation to prevent us from being able not only to get to the bottom of the outrageous weaponization of our intel and our Justice Department, but also to just carry on, pass a bill like being taken up here so that we can actually move forward, save money for the federal government, make sure hurt people are taken care of, but without running up the price tag on the American taxpayers. So, you know, I've come to develop very warm feelings of friendship with some of the folks on the other side of the aisle, and I'm just saying, it's not going to look good in the decades to follow when people look back and they don't see Democrats the way the Republicans were during the Watergate hearings. They see obstruction, obfuscation, pointing here, there, and beyond, righteous indignation to prevent us from correcting maybe the most disastrous constitutional crisis, certainly in my lifetime. But that is the reason I now move to table the gentleman's motion.
Motion has been made to table the motion of the gentleman from Rhode Island. All those in favor respond by saying aye. Aye. Those opposed, no.
No.
The chair, the ayes have it, and the
Request a
motion.
recorded vote,
Roll
Mr.
call vote is
Chairman.
requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes aye. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Issa? Mr. King? Mr. King votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Poe votes yes. Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Gowdy votes yes. Mr. Labrador? Mr. Labrador votes yes. Mr. Farenthold? Mr. Farenthold votes aye. Mr. Collins? Mr. DeSantis? Mr. DeSantis votes yes. Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. Rutherford? Mr. Rutherford votes aye. Ms. Handel? Ms. Handel votes yes. Mr. Nadler? No. Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? No. Mr. Johnson votes no. Mr. Deutsch? Mr. Deutsch votes no. Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? No. Mr. Jeffries votes no. Mr. Cicilline? No. Mr. Cicilline votes no. Mr. Swalwell? No. Mr. Swalwell votes no. Mr. Liu? Mr. Raskin? No. Mr. Raskin votes no. Mr. Ipaul? Mr. Schneider? No. Mr. Schneider votes no. Ms. Demings?
Clerk will report.
Mr. Chairman, 18 members voted aye, 9 members voted no.
And the motion to table is agreed to.
Mr. Chairman.
I now recognize myself for purposes of offering an amendment, and we are waiting for that amendment to arrive at the clerk's desk momentarily.
Mr. Chairman.
Mr. Chairman, Mr. Chairman,
I've recognized myself. I'm controlling the time.
I move to strike the last word.
I've recognized myself for that purpose.
I asked the gentleman to yield to me so that I can move to strike the last word.
I'm sure the gentleman's
While we
eloquence
wait.
would be great, but I'm happy to have the clerk report the amendment in the nature of substitute.
Amendment in the nature of a substitute to H.R. 3808 offered by Mr. Goodlatte of Virginia. Strike all that follows.
Without objection, the amendment be considered as read, and I recognize myself to explain the amendment in the nature of substitute. As I mentioned previously, H.R. 3808 would apply only where federal funds were used on an infrastructure project. In such cases, the bill would apply a comparative negligence liability standard to gravity-related injuries that occurred on such projects, a standard that considers the comparative negligence of the injured person when such negligence is a proximate cause of an injury to a person. The base bill applied that standard because it is the majority standard and also applies in New York outside the scaffolding context. However, some states also use a contributory negligence standard. Because today every state uses some form of comparative contributory negligence liability in tort cases generally, I am offering this substitute amendment, an amendment in the nature of substitute, that will also allow courts to use the contributory negligence standard, thereby preserving all state law general liability standards other than New York's scaffold law when federal funds are involved. States should be free to impose their own laws, state laws, where state interests govern, but where federal laws are involved, no state should be able to impose an absolute liability rule that substantially increases infrastructure and housing costs to federal taxpayers. I urge my colleagues to join me in supporting this amendment in the nature of substitute. Are there any amendments?
Mr. Chairman.
Are there any amendments to the amendment in the nature of substitute?
Would you yield
What
for a
purpose does the
question?
gentleman from Maryland seek recognition?
For a question for you, Mr. Chairman, about the nature of your amendment.
Yes, the gentleman is recognized for 5 minutes.
Thank you very much. Just to address this amendment first, and I wanted to go back to something that Mr. Gohmert said as well, but as I'm reading your amendment to H.R. 3808, it says that for any project, I'm reading from line 15, for any project for which federal financial assistance is used, a state shall, for any claim brought by a covered person otherwise available against a property owner or contractor for any injury associated with the elevation or gravity-related risk, apply a comparative negligence liability standard that considers the comparative negligence of the injured person, or a contributory negligence liability standard that considers the contributory negligence of the injured person when such negligence is a proximate cause of an injury to a person. Am I understanding this correctly, Mr. Chairman, that you're giving each state and each state court the choice of a comparative or a contributory negligence standard? And is it in each case that it may choose, or is it in this category of cases? And who does the choosing? Is it the state judiciary, or is the state legislature that's being essentially imposed upon by this legislation?
The answer is yes, the state can choose, but only in this category.
Okay, and when you say the state can choose, this operates directly on the courts. So the court can say, we will use a comparative negligence standard or a contributory negligence standard.
Yeah, this is the standard that already applies in the courts in every other state.
Okay, but for the first time, so for example, my state has a contributory negligence standard, but now my state could apply either a comparative or a contributory negligence standard under this new federal law that we're imposing on all 50 states.
Well, if there's a statute in the state of Maryland that requires a standard to be imposed, the court will be able to apply that standard, whereas under
Well, but it's being overruled by this law, isn't it? In other words, this law supersedes all 50 state laws, doesn't it? So my state, now, the courts presumably under this federal legislation would be able to say, we're going to use comparative or contributory.
the background, whatever the state of Maryland requires is what will be imposed here, because the state of Maryland has passed legislation that dictates that, and we simply want to recognize that the state of Maryland might have a standard different than was set forth in the underlying bill, and so this amendment in the nature of substitute gives Maryland the authority to recognize the standard that they recognize now.
Well, what if a state, and many of them do, have a common law standard that has been adopted by either contributory or comparative negligence? Would this not overrule the common law in order to say that the state courts would have to apply or could apply either a comparative or a contributory standard?
Well, with gentleman yield, this would allow that state to recognize that common law standard that they recognize under their law.
I just don't read this language in that way. I mean, it seems to me, I understand if your purpose is basically to say that any state can choose contributory or comparative negligence and have that as its rule, or that the current law is not superseded except in New York, then it could be written in that way. But I think what this says is that any state, and I don't know whether, I mean, again, because this is a rather radical overruling of federalism and state law, but I read it to say that the courts could choose to adopt one or the other, regardless of what the state legislature has said. That's the import of this federal legislation.
The court is going to look to their state law and imply that.
Well, why is this necessary then? I mean, in other words, if you're just silent on it, why wouldn't you just go back to it?
The gentleman yield.
Whatever the bill simply says, whatever the law is, the state continues to apply.
Will the gentleman yield?
Well, I'll yield in 1 second, but here's the issue I'm having, just conceptually. And again, we're not having an ideological disagreement here. We're just trying to figure out what this language means. Right now, there's a spectrum of laws in the states. There are pure contributory negligence, there are modified contributory negligence, there's pure comparative negligence standard, there's modified comparative negligence, there's strict liability, which this seems to be targeting. And then you say everybody's got to fit into peg A or peg B, square A or square B. And it's also not clear whether that's operating directly on the state legislature or directly on the courts, because you know, as I understand it, we've never done this before. We're basically usurping the state's power to define tort law. But I don't know what the import of this is, and I'm happy to yield.
Thank you. I thank the gentleman for yielding. It might be clarified if you inserted a clause following on line 5 on page 2, simply that said, according to the laws of the state. So you've effectively repealed the strict liability provision that is the scaffolding law, but you have allowed the states to apply the laws of their state with regard to vis-a-vis comparative negligence or contributory negligence.
Can you draw that up? Would you draw that up? I'd be very happy to look at that. But right now, I want every member in this room to understand this is targeting your state's law, because right now this says that every state's law is thrown into doubt, in essence, that the state courts in your state can impose contributory even if you're in a modified comparative jurisdiction, or you can impose comparative if you're in a strict contributory negligence jurisdiction. I think that this needs to be written at the very least in order to clarify what it's saying. I mean, we're obviously in dangerous territory when we're trying to change the law of one state, which is what this bill is all about by the explicit account of its own authors. But the language is written in such a way as to level what's going on across the states and to force everybody into one camp or another. And again, it's not clear to me whether this is operating on the state legislatures, whether their processes are being commandeered, so they've got to change their law, or whether the courts themselves are supposed to interpret the meaning of this federal legislation. So,
If the gentleman would yield.
yes, by all means.
I would just simply, again, say to the gentleman that I think his reading of the amendment in the nature of substitute is not correct, and that states will, as they should, impose the law, any subset of either comparative negligence or contributory negligence that they have in their state will continue to be imposed under this amendment.
Well, it doesn't say that, Mr. Chairman. I'd be very happy to look at an amendment that does.
I just have to disagree with the gentleman.
Okay, well, I'm happy to yield back. Thank
Are
you
there
very
any
much.
amendments to
Mr.
HR 3808?
Mr. Chairman, I'd ask to strike the last word as to the amendment in the nature of a substitute.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, let's not get this bill twisted up in terms of legalese and wording. The bottom line about this bill is that it seeks to usurp a 100-year-old New York statute so that it can protect big money New York developers like President Donald Trump, big money real estate developers in New York, Donald Trump. Let's not get this twisted up. This is legislation designed to protect Donald Trump, who has been the subject of scaffolding lawsuits, he and his enterprises, throughout the years of his doing business, where workers have been killed or grievously injured as a result of scaffolding collapses or falling off of scaffolding. So this legislation is exactly what Donald Trump wants, and whatever Donald Trump wants, Donald Trump gets from this Congress. It doesn't matter which committee it is, whether or not it's judiciary, whether or not it's intelligence, whether or not it's oversight and investigations. He gets whatever he wants. He uses his bully pulpit in a blustery, overbearing, and badgering way to intimidate people here in Congress, Republicans, into doing whatever he wants them to do. This is an example of it. One day, less than one day after the House Intelligence Committee Republicans take the astoundingly dangerous step of agreeing to release a memo with classified information in it that has not been approved by our intelligence apparatus nor by our law enforcement apparatus. In fact, DOJ has warned of how dangerous and inappropriate the release of that Devin Nunes memo would be. But yet, Republicans on the Intelligence Committee voted to release the document, wouldn't even accommodate the Senate Intelligence Committee, who requested to see the document before it was released, before the vote of the House Intelligence Committee. House Intelligence Committee refused to share the classified document prepared by Nunes with the Senate. It's stunningly inappropriate for this Congress to act this way. So across the board, we see people doing everything they can to protect the Trump administration and to protect the private enterprises of this president, Donald Trump. It is amazing what is going on in America today on all levels in this Congress. It speaks to why it is so important for the voters to pay attention to what's going on, connect the dots, and they're not hard to connect because every time you look around now, there is something that this Congress is doing to protect Donald Trump, and they'll do it regardless of whether or not it hurts America or not. There's a reason why this American flag that I have on my lapel sits above this congressional pin that I'm wearing. This flag is what this congressional pin is all about. So in other words, we should be here not to protect a politician and to enhance our partisan politics. We should be about protecting the republic, which is represented by this flag. And this Republican-controlled Congress is showing exactly the opposite. I wish that every legislator would think about the framers of our Constitution and what, from their graves, they must be thinking about when they watch what's going on in Congress today, when they see in every committee throughout this Congress what is being perpetrated on our Constitution, how you're trying to destroy our way of life. And with that, Mr. Chairman, I will yield back.
Chair, thanks, gentlemen. First, the gentleman from Texas seek recognition.
Mr. Speaker, I move to strike the last.
Gentleman is recognized for 5 minutes.
Mr. Chairman, I just want to express my resentment to the gentleman who just spoke. Labeling Congress as a rubber stamp for the president, to do whatever the president wants, that's what Congress does. I resent that. I'm a member of Congress, and I make my vote based upon what's best for the country and the people in Texas that I represent. So I just want the gentleman to know that I resent his remarks a great deal, accusing Congress of, I think, malfeasance, especially the Republicans. The issue before us today is not President Trump. The issue today before this committee on this bill is really pretty simple. It's whether or not Congress, this committee, should pass a specific law in the state of New York to change New York's liability laws. And the argument I hear is, well, we need to save taxpayer money. So that's the federalism issue before us, whether there is a federal issue of saving taxpayer money because of the law in New York. It seems to me that the 10th Amendment, what's left of it, continues to be eroded away. And I personally don't have a stake in what happens in New York at all. I seldom agree with the ranking member. I know this makes him nervous that I'm agreeing with him today. But I don't think Congress has any business at all dealing with this. This is not our issue. It's a state's issue. And if the state of New York wants to have strict liability and it costs more money to whoever, the insurance companies, well, that's not our business. It's New York's business. And I don't think Congress ought to be involved in this issue at all. What's next? What state are we going to pick on next to go in and change their liability laws? So, in all due respect to the chairman and the members who have sponsored this bill, this is a federalism issue. It's not Congress's issue. It's New York's problem or issue. They don't want to deal with it. Well, then New York, don't deal with it. But it certainly shouldn't be our issue. And big federal government comes in and says, well, you don't have the liability laws we like, we're going to change it based upon money factor. So I will not support the legislation, but I do want to make it clear that I base my vote, and I think most members on both sides base their vote totally on what's best for the country, what's best for the Constitution, and what's best for the people that we represent. So I yield back to the
Would the
chairman.
gentleman yield?
Yes.
I thank the gentleman for yielding. I appreciate his sentiments, but I just want to make this very clear. This bill relates directly to federally funded infrastructure projects that connect state roads and bridges. It is squarely within Congress's constitutional spending clause and Commerce Clause authorities, the very same clauses that support Congress's authority to establish a federal highway system itself. Under this bill, if New York wants to preserve its scaffold law, it's entirely free to do so by simply refusing federal funds. If state and private funds are the only funds involved in an infrastructure project in New York, the scaffold law will continue to apply. But if New York wants federal taxpayer dollars, those dollars are going to have to come with reasonable conditions, including a requirement that federal taxpayer money not be used to pay for things that are the fault of others. True federalism allows federal conditions to follow the use of federal funds. False federalism, federalism turned on its head, demands that federal taxpayer dollars subsidize the cost of state laws. This bill stands for the principle of true federalism. Federal taxpayers, through their elected federal representatives, should control how their federal taxpayer dollars are spent. I respect the gentleman, but I respectfully disagree.
Reclaiming my time. We do disagree, Mr. Chairman. I think that this is a responsibility for the state of New York. It's not our issue, and I think that we, in all due respect, I think this is a state's 10th Amendment issue totally. And then I'll yield back my time.
I thank the gentleman for yielding to me. What purpose the gentleman from New York seek recognition?
Strike the last word on the manager's amendment. On the
Gentleman is recognized for
amendment
5
nature
minutes.
Substitute. Thank you. Let me begin by pointing out to the gentleman from Texas that I thank him for agreeing on this, but I also want to point out we agreed on the FISA amendments on Section 702. So this is not unique, but it is obviously, but the gentleman is correct. This is a federalism issue, and we have too often invaded the provinces of the states. It used to be a standard Republican argument. Maybe I'm showing my age by remembering this, but it used to be a standard Republican argument against most federal spending proposals of any sort that it would be used to tamper with states' rights to make their own decisions. And that was an argument, and many of us dismissed that argument by saying that wouldn't happen, and you could the states' sovereignty and would continue to be respected. But here we're showing, at least to some extent, the validity of that old Republican argument. I don't think it's valid to say we shouldn't spend money on the federal level, but we should refrain from dictating to the states. And I rise in opposition to the amendment in the nature of a substitute, which would add the ability for a defendant in a case covered under the bill to avoid liability by citing plaintiff's contributory negligence. This amendment in no way addresses my principal concern with the bill, which is that any changes to the enforcement scheme of New York's scaffold law should be considered by New York's legislature, not by Congress. And I must say, this makes me feel younger because I remember debating this bill in the legislature when I was a member of the Assembly about 30 years ago. Under a contributory negligence regime, even if a plaintiff is only 1% at fault, the defendant is entirely free from paying any damages at all. It is an old tort rule that only a handful of states still retain because of its manifest unfairness, and especially unfair in a situation like this where the employer sets the conditions of the work. The employer decides what kind of scaffolding to have. The employer, the contractor, the employer decides what safety protections will be in place. The worker works at the risk of whatever safety is in place. The state of New York has decided that in order to protect the workers, the only thing that works is to have strict liability, not in the normal tort sense, but in the sense that if you do not maintain, you, the contractor, do not maintain a safe working environment, and if it is shown that the failure to maintain that safe working environment contributed to the injury, then you are at fault. And we're not looking at a comparative injury provision, or even worse, contributory. Under the amendment in the nature of a substitute, if the employer refuses to have any safety mechanisms at all, and as a result, 99% of the fault for the injury, for the death of the worker, for example, is because of the refusal to maintain proper safety standards, which is the choice of the employer, not the employee. But if the employee was at all negligent, 1%, then the employer is totally off. Under that standard, you're not going to see very many safety protections. That is why the New York legislature chose in the 1880s and the 1980s and currently to maintain the law the way it is in New York. We can debate the intelligence of the law, but it is a federalism issue. It is a New York law. There have been the statistics, by the way, that were cited before about the insurance costs. The reports that were cited before that the scaffold law greatly increases the insurance costs and so forth. That report has been attacked on the grounds that it does not rely on actuarially grounded data to support the assertion that the law causes an increase in insurance premiums, and insurance companies have refused to allow the public to scrutinize their data and have opposed past New York State legislative proposals to make such data available for public review. One assumes that if, in fact, the data which the insurance companies have supported the assertion that, in fact, the insurance premiums are substantially higher and the costs are higher because of the scaffolding law, they would let the public, they would let the government in New York see this information. One has to assume that because they refuse to let anybody see this information, it's because that information does not support this assertion. So we have an amendment here which makes the bill even worse because it says that you can have contributory, not comparative negligence, where no matter how egregious the violation of safety standards, the refusal of the employer to have safety standards, if there's any negligence by the employee is liable, not the manager. And therefore, you're going to have the predictable result of this bill, if it passed, is a great reduction in investment in scaffolding and in other safety measures, and a great increase in deaths and injuries to workers. And because the manager's amendment would cause this, and because it does not address the concern with overriding New York State law, which we have no reason to do, may in fact exacerbate the federalism concern, I must oppose the amendment. I yield back.
Are there any amendments to the amendment in the nature of a substitute? He's already spoken on this. You haven't offered your amendment yet. No. Does the gentleman from New York care to offer an amendment?
No.
All right. Question occurs on the,
Mr. Chairman, I move to strike the last word,
the gentleman was recognized for 5 minutes.
and I yield to Mr. Raskin from Maryland.
I want to thank the gentlelady for yielding. So if all of this is really designed to have us sit as the super legislature of New York and overturn the laws of New York, I'm wondering about what the concrete effects of passing this legislation are. The only one who might be able to predict this is Mr. Nadler, since he served in the New York legislature. But let's say that we enact this legislation, and the New York legislature takes the position that under the Prince versus United States case in 1997, or the hazardous waste control case, or South Dakota versus Dole, that this is totally unconstitutional, and they refuse to enact a statute codifying either comparative or contributory negligence. And they cite all of their legislative history about the unique dangers associated with, working at skyscraper level on scaffolding, and they invoke the dozens of people who have fallen to their deaths that way, and they say this strict liability regime is working, but they say it's been debated in the legislature, but this is where they come out and they say we're not doing anything else. At that point, I understand it, the New York state courts would have to interpret federal law. But given the A or B under Mr. Goodlatte's amendment, is it left up to the judge to determine whether they're applying comparative negligence or contributory negligence at that point? Does the court get to decide? So this is one of the baffling brain teasers caused by Congress sitting as a super legislature for the state of New York. But look at if you don't care about New York's legislature and their federalism, and I do want to salute Mr. Poe for his distinguished and principled federalism that he's just stated here. But let's say you don't care about the people of New York. You say it's a blue state. We don't care if we trample their laws. What about the laws in your state? Most states have a comparative negligence law. But this federal legislation says that the courts can apply either comparative negligence standard or a contributory negligence standard. At least as unclarified at this point, it just throws a bunch of mush into the state law of every one of our states. And so if you want to make a surgical strike against New York and say, we don't like the balance of power in the New York legislature, we're going to overrule you, and we're going to use a sledgehammer to do it, then do that. At least do that. Target the people of New York if that's really what you're after. But this throws the tort laws of every state in the union completely up into the air. We don't know whether this applies against the states, which is almost certainly unconstitutional, against the courts, which just introduces all kinds of vagueness and uncertainty into the tort law system. So I think this is a good argument for the design of the framers, for the design of the 10th Amendment, and for our respecting the rights and the powers of the people of the states to decide tort law for themselves. And if we don't want to spend our money in New York, let's not spend our money in New York. Fine. Let's not do it. But let's not try to use the spending of federal money as a lever by which to overrule the considered legislative judgment of the people of New York. And so,
Reclaiming my time,
Yes.
I would note that there are a long line of cases indicating use of the funding authority in this way will fail on constitutional grounds, as the member from Maryland has pointed out as a former constitutional law professor. But it's also bad policy. Why do we think that we know better what the tort law ought to be in the various states? I've never voted to do that, and so far as I can recall, and often opposed it, even when I might have, on the merits of a bill, agreed. That's just not the proper role for the Congress. And with that, Mr. Chairman, I yield back.
Mr. Chairman.
For what purpose does the gentleman from Texas seek recognition?
I was in support of the manager's amendment.
Gentleman's recognized for 5 minutes.
I have made the prior chairman from my own state, who is a very, very dear friend, very, very angry in our prior efforts to change medical malpractice laws in all states in the Union. Originally, there was just basically no federal nexus, and it was totally inappropriate. And the arguments were made here, yeah, but you did tort reform in Texas. Don't you want Illinois and every other state to have your good tort reform? And my response was always, that's up to the individual state. In this case, and I appreciated the comments of my friend Mr. Raskin, because it did make me look again at the language. And as a former judge that would have had to apply this kind of law, we're basically, I think there's enough federalism at play here. When the federal government is going to be paying for a project, and especially when tonight I expect the president to lay out a program for helping with infrastructure around the country in places where the federal role is appropriate. If a state is saying it's going to be strict liability, so the federal government, you're going to do infrastructure in our state, you're going to have to pay a whole lot more because you're going to be strictly liable, then I think, as the chairman pointed out, the question is, well, do you want the federal help or not? Because if you do, and there is an injury that results, then it comes back to the judge, and as it says here, where there's federal financial assistance, a state shall, and you get over to the top of page 2, apply a comparative negligence liability standard or a contributory negligence liability standard, whatever the state has. And if this were a law I was having to apply in one of the lawsuits in my court, then I would look at the state law, which do we use here in Texas, and that's what we would use. This bill gives that opportunity. So I certainly appreciate the concern of my friend Mr. Raskin, but I think this is adequate to give enough. Yes, I yield.
Thank you. I would point out, Mr. Gomert, the bill does not, the manager's amendment, the amendment, the nature of a substitute, does not talk about only, if we're giving the states money, where you might make a case. It says federal financial assistance is used directly or indirectly. This could be a tax credit. It could be an SBA loan. So we're not talking, and it's undefined, and we've had no hearings, so we're not talking necessarily about a federal expense at all. We're saying if there is a tax benefit of a fixed amount, if there's an SBA loan of a fixed amount, then we're dictating to the state what its tort law ought to be. And as somebody may say that doesn't include that, but it says federal financial assistance is used directly or indirectly. It would seem to include that. And again, we've had no hearings in which to elucidate the meanings of these terms. So I could understand the gentleman's argument. I wouldn't agree with it, but I could understand it if the bill were limited to where the federal government is paying for part of the project with direct cash grants, and then you could say, well, if we're paying for 10% of a larger expense is a larger amount of money, so this tort rule in New York is costing the federal government money, but we're talking also apparently about a tax credit or about an SBA loan where it doesn't cost the federal government any money.
Well, reclaiming my time, I see what the gentleman's saying about for any project there at the top of A, it does say directly or indirectly, and then that addresses the absolute liability issue. But then down at line 15, it makes it's any project for which federal financial assistance is used and doesn't use the term directly or indirectly in setting out the use of comparative or contributory negligence. So I think it would need to be more direct than indirect, and I would see that being left up to a state judge as I was. But gentleman makes good points, but I think this may be an exception where I will come down on the side of the manager's amendment. and be one of the rare cases where I don't have the chairman furious at me in this area. And I yield back.
Mr. Chairman,
Chairman?
Chair, thanks, gentleman. Floor person, gentleman from Texas, seek recognition.
strike the last word.
Gentleman's recognized for 5 minutes.
Thank you very much, Mr. Chairman. First of all, the usual standard bearers of the question of states' rights are my friends to my right. So I'm somewhat speechless in moving to strike the last word, Mr. Chairman, on the context of this legislation. First of all, for those of us who've had the opportunity to live in New York for a period of time, to travel to New York for a period of time, we realize that New York, and New York City in particular, has a proclivity for heights. They also have a proclivity for very old buildings. And they have had, over my recent time in Congress, building collapses, large equipment falling into buildings, and in the mix, there are construction workers. So first premise is that we're eliminating states' rights by New York's determination on how they would solve the problem of construction with heights. In a letter to our ranking member dated September 21, 2017, the New York State AFL-CIO, not the national, so this is states' rights and state information, says construction, particularly work at heights, is extremely dangerous. Maybe we are not aware of that. One workplace death is one too many, but some parts of the state, New York City, for example, there has been, or they have seen, an epidemic in construction death. The last thing we can do is afford to roll back safety. Now, let me say that I am a strong advocate for Habitat for Humanity. They do enormous work. But in this instance, I would wish the Habitat for Humanity's national entity representing their great work would meet with members of Congress and meet with the legislators in New York, besides sending a letter, and so that we could explain the inadequacy of snatching from the state its rights to regulate its workplaces, and that there can be some respectable acknowledgement of entities like Habitat for Humanity. What strikes me, and obviously I know everyone builds high up in New York, I'm not familiar of them building skyscrapers. So if it has been a hindrance to helping Hurricane Sandy victims, I'll be the first to find a pathway for them to do that. But if you read the manager's amendment, rather than full rights for the injured or deceased individuals' families, let me just read this for you. So this nexus is, of course, federal funds, federal financial assistance. By the time we get through with the tax bill, we won't have a dime anyhow to provide any financial assistance, but the financial assistance, and it says, for any claim brought by a covered person otherwise available against a property owner or contractor for any injury associated with an elevation or gravity related risk, apply a comparative negligence liability standards that considers the comparative negligence of the injured person, or a contributory negligence liability standard that considers the contributory negligence of the injured person when such negligence is a proximate cause of an injury to a person. Now, if anyone has seen individuals on scaffolding, many of them are individuals who are immigrants, many of them vulnerable people who are intimidated by any form of government, and you're going to argue, I assume the employer is responsible for a drunk employee because you know that employee is drunk. They shouldn't be on the scaffolding anyhow. But what is the negligence of an individual at 102 stories or 90 stories, and the wind comes and they fall? And who is there to document the negligence of that employee? Should have had 2 feet strapped down with chains. They didn't take the chains up there. This is an abomination, and it goes to the well-meaning but unfortunate insensitivity of knowing what it means to work for a living. There are other ways to address the question of Habitat for Humanity. This is only addressing the question of the pocketbook of large construction companies interfering with the legitimate legal structure and choices made by New York State.
The time of the
I'm
gentleman
sorry,
has
Mr. Chairman,
expired.
I oppose the underlying bill and the amendment in the nature of a substitute.
What purpose the gentleman from Arizona seek recognition?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I support the amendment in the nature of a substitute, and I appreciate this discussion, how it's turned to the federalism issue, because when I first read the underlying bill, I immediately had some federalism concerns, but I got to thinking, you know, we in Arizona, we pay a lot of federal tax too. And when I saw the limitation in this bill, and in the amendment in the nature of a substitute in line 15, which particularly talks about for which federal financial assistance is used, I became comfortable because we're chasing federal tax dollars that my constituents would otherwise be on the hook for. That's what this became for me. But I'm very excited to hear what I think the gentleman from Texas just said, and I think I wrote down her comment. She's concerned that we are snatching states' rights to regulate its workplaces. Well, you know, I did in Arizona. I worked on the fall legislation in Arizona, and we were greatly constrained in regulating our workplace by not just state laws, but oddly enough, the federal OSHA requirements. And those federal OSHA requirements come into play at low heights and at great heights in the scaffolding and in the construction industry. So I'm just excited to hear my friends across the aisle now say they want the states to regulate its workplaces. I hope that expands to everything, and we can start saying, well, OSHA, get out of the states' ways. They're going to start regulating. So I'm a bit surprised that my friends across the aisle have turned this into a federalist issue on this one lone aspect, but they're willing to let federalism go away on the actual regulation part of it. So, Mr. Chairman, I think federalism applies here because the federal taxpayer is on the hook. And so with that, I yield back, Mr. Chairman.
Mr. Chairman.
Purpose the gentleman from Florida seek recognition.
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Thanks, Mr. Chairman. I'll leave the federalism argument to others. I'm going to just try to be really simple about this. Fact is, most people don't work on scaffolds. They don't work high above the ground. But if you ask them anywhere, your district, my district, anywhere in America, if they think that there should be some liability if there's an accident, if and only if the contractor or owner failed to provide proper protection, they would say, yeah, that sounds about right. That's what the New York law is. I don't understand why we would want to reject that. It seems pretty clear that the people who are in the best position to protect workers are the ones who ought to take those measures.
The gentleman.
I will not at the moment. But I want to just make another observation. To the extent that there's anyone who happens to be taking a look at their television listings and they see that there's a meeting in the Judiciary Committee of the House of Representatives, they might have tuned in this morning. And they probably thought, well, gee, since the last time the House met, last Thursday, we learned that the President of the United States attempted to fire, not just attempted, demanded that this special counsel be fired last Thursday. So clearly the House Judiciary Committee is going to want to take that up. And then Then we get into this week, and the day before our committee, the House Judiciary Committee, they would look at the news and see that there is an investigation of the Department of Justice and the FBI that the Intelligence Committee is pursuing. They see that the Republican leadership on the Intelligence Committee has chosen to selectively release classified information against the advice of law enforcement, potentially putting at risk sources and methods. All of that falls squarely within the judiciary's jurisdiction. And they might think, I'm going to tune in because clearly this is something the House Judiciary Committee is going to take up today. And they might put this in the broader context of the investigation into, let's remember, the Russian interference in our last election, an investigation that at this point has already produced guilty pleas and indictments against the president's campaign manager and the president's former national security advisor and others. It's an investigation that's already disclosed and uncovered a secret meeting that took place at Trump Tower between the president's son and Jared Kushner and agents of the Russian government. All of this is going on. Clearly, the House Judiciary Committee's got to be a part of that. There's got to be outrage. There's got to be, given these efforts to discredit Mueller, those on this committee who refer to a coup d'etat being waged, the secret society allegation, all of this, the Judiciary Committee's got to be outraged. They're going to want to do something about it, aren't they? Well, obviously, the answer to that is no. And Mr. Chairman, I would just ask unanimous consent to put into the record the text of Rule 11, this is the Rules of the House of Representatives, Rule 11, Clause 2, Section G3B and Section G4. These are the rules that make clear that the House, this committee, with less than a week's notice or 3 days' notice to members, can actually call for a hearing. The chairman with the concurrence of the ranking minority member or a majority of the committee. And then G4, which is the provision that says that legislation can be brought up in less than 24 hours, again, using that same standard. And I ask that that be entered into the record.
Without objection, that will be made part of the record.
I appreciate that, Mr. Chairman. And given that information, my hope is that as we go forward from here today, knowing that the rules permit us to move quickly to take action, that we will, in fact, quickly move a majority of this committee to bring up H.R. 3771, which is the Special Counsel Integrity Act, a bill that on the Senate side we all must acknowledge is a bipartisan effort to protect the Special Counsel so that he can continue to do his work into the attacks on our democracy by Russia, because ultimately that is really what we are focused on, and that investigation lead to wherever the investigation takes the Special Counsel. I hope that we'll be able to do that, Mr. Chairman, and I yield back the balance of my time.
Are there any further amendments to the amendment in the nature of substitute? For what purpose does the gentleman from New York seek recognition? Gentleman's recognized for 5 minutes.
Mr. Chairman, I just rise at this moment to address something that was said by one of our colleagues on the other side of the aisle who mentioned that in defense of his perspective that this does not implicate federalism, his constituents in Arizona were on the hook. And I would just argue that his constituents in Arizona are not on the hook for a dime. There are two types of states in this country, donor states and taker states. Donor states like New York, New Jersey, Connecticut, California, Illinois, regularly send more money to the federal government than we get back in return. Then there are taker states, many in the Deep South, many represented by my colleagues on the other side of the aisle, who regularly receive more from the federal government than you give back in return. Every year, New York sends $40 billion more to the federal government than our taxpayers get back. So don't lecture us about taxpayers you represent being on the hook. That's a joke. Now, I want to thank the distinguished gentleman from Texas, Mr. Poe, for his ideological consistency. And I would humbly suggest that more of that is needed on both sides of the aisle. But I thank the gentleman from Texas, Mr. Poe, for his persistence in this regard. And let me simply just posit a few questions. I'm struggling to figure out what the Republican Party represents. I really am struggling. You claim to be the party of fiscal responsibility, yet you saddle our children and grandchildren with $1.5 trillion in additional debt simply to pay for tax cuts for millionaires, billionaires, corporations, and big donors. Are you for fiscal responsibility or are you against it? You claim to be the party of law and order, yet regularly attack Department of Justice officials and FBI agents who are simply doing their job to keep the country safe. Are you for law and order or are you against it? You claim to be the party of foreign policy hawks, yet many are providing aid and comfort to Russian spies who interfered with our election, according to 17 different intelligence agencies, for the purpose of helping to artificially elect 45. Are you foreign policy hawks or are you not? Claim to be the party of the rule of law. And yet many regularly attack Special Prosecutor Bob Mueller, who prior to his appointment was widely regarded on both sides of the aisle as a talented, pristine law enforcement professional who has sacrificed much for our country. Are you for the rule of law or are you against it? You claim to be the party of family values, and yet the highest ranking Republican official in the land endorsed and supported and campaigned for an accused pedophile and child molester for a United States Senate seat. Are you for family values or are you against it? And then on today, you claim to be the party of states' rights. And yet, we've got a bill before the committee that implicates a single donor state on a question of tort law that has never been a matter of federal jurisprudence. Are you for states' rights? Are you for federalism? Or are you against it?
Gentleman yield.
Gentleman, yield back.
I yield back.
Gentleman, yields back. Are there further amendments to the amendment in the nature of substitute to H.R. 3808? This is the gentleman from California, Mr. Swalwell, seek recognition.
Thank you, Mr. Chairman, and I appreciate the bipartisan concerns about this bill. It truly is bipartisan, and I won't rehash them, but one of my biggest concerns is that the work that people do when they're on scaffolding, whether it's in New York or any other state, is inherently dangerous work. These are typically low or middle-class workers who don't have a lot of the insurance policies and safety nets that the developers and builders who employ them have. But what they've always had has been a justice system that promises that if wrongdoing occurs at their job site, that the lawmakers in this country and the courts in this country will have their back and will make them whole. That's a promise that has always been made under our justice system in this country. It's gone through iterations, it's seen abuses, but today workers are better protected because in a bipartisan way we've come together to protect them. And this bill would certainly undermine that and reduce an injured worker's or a grieving family's ability to become whole again, or at least find some sense of recovery. But I also want to address this absurd suggestion that New York's scaffold law is a strict liability scheme. It's been a while since I went to law school. Certainly wasn't at the top of my class, but strict liability means that you're liable regardless of your culpability. That is not the New York law. You can only be liable if a court finds a violation of the statute's requirements that the contractor, employer, or property owner did not provide proper protection. So there has to be a finding under this statute in New York that proper protection was not provided. You go to any bar, any church, any gathering of people in our country, and you say, hey, do you think workers should be protected in our justice system and be made whole if the employer didn't provide proper protection and they were injured? Should their families find relief if they were killed? Who would be opposed to that? I don't know a single person who would be opposed to that. So this bill is really just a solution in search of a problem that doesn't exist. It looks like New York State got it right. But the larger issue here, and I will yield to my friend from Maryland in a moment, the larger issue here is this committee would set a precedent of going after any state, county, municipality, water board policy that we do not like, completely disrespecting any constitutional norms or notions of federalism, and doing the bidding of people who, one, don't need it, like developers and builders, at the cost of people who have always counted on us, working Americans. And so I'm opposed to this, and Mr. Chairman, I'll yield to the gentleman from Maryland.
I thank the gentleman from California very much for yielding. The language here appears to apply to change the laws of all 50 states. That's an interest that's been disclaimed by the authors and by the chairman. Apparently it applies only to one state, to New York, but based on what was just suggested by Mr. Swalwell, it's not clear that it applies even to New York. The language has no action on the basis of absolute liability may be instituted by a covered person against a property owner. But New York's law is not one of absolute liability. It's not enough to show that you were on the premises and you were injured by the scaffolding in a gravity accident, because if it's your fault, if the only proximate cause is your own behavior, if you get drunk and you fall off, that is an absolute defense in New York. So I'm not sure that this language applies to any state, at least based on the representations and based on fair inferences from the language. I'm not even sure New York's got anything to fear from this, because it does not have an absolute liability regime. It does have this defense if the sole proximate cause of the injuries are the actions of the employee, him or herself. All of which goes, again, to say, let's let the states work out their own tort law systems. Let's not sit as a super legislature for the people of New York. I yield back.
Mr. Chairman.
Mr. Chairman, I ask unanimous consent to insert into the record a number of letters in opposition to this bill.
Without objection, they will be submitted to the record. We have very limited time because we have a vote on the floor.
Mr. Chairman.
Does the gentleman from Rhode Island seek recognition?
Move to strike the last word.
Will the gentleman be brief?
Yes, I will, Mr.
The
Chairman.
gentleman is recognized.
Thank you, Mr. Chairman. I rise in opposition to this bill as amended. First of all, for the obvious reason that the responsibility to make this judgment rests with the New York legislature, and it is both, I think, a violation of federalism, but also a violation of the practice of this committee. And as Mr. Deutsch said, people tuning in might think we'd be taking up important issues, whether it's our oversight responsibility, whether it's fixing our broken immigration system, whether it's doing something to reduce gun violence or reform our criminal justice system, and instead they see us meddling with the judgment made by duly elected people serving in the New York State legislature. Second point is, these are incredibly dangerous jobs. There's a reason that the General Assembly of New York enacted this statute a long time ago, because it recognized that this is dangerous work, that these are difficult jobs and difficult conditions, and when people get hurt, they have a right to ensure that they are compensated and their families are compensated. And the notion that Congress is going to intervene in a way that protects the big, wealthy developers at the expense of working people, this is exactly what people think Washington does. They intervene to help the fat cats at the expense of working people. This is a terrible idea. I urge my colleagues to vote against this, to recognize the difficult and hard work that these individuals do,
gentleman
and their
yield
right to be protected.
For a
I
moment
yield
to submit
Chidele
something into
from-
the record, Mr. Chairman.
Yeah, what purpose does gentlewoman seek recognition?
To submit into the record with one qualifying sentence, life should not be measured by dollars and cents. And so this bill undermines the very thought that a loss
Without
of life.
objection, that document.
The amendment, what I'd like to submit is the idea of what we should be doing, Mr. Chairman, is H.R. 3654, which is my legislation with 40 other members of Congress, the Special Counsel
The
Independence
gentlewoman's
Protection Act. Ask
document
unanimous
is,
consent.
without objection, made a part of the record.
Thank
The
you.
question occurs on the amendment in the nature of a substitute. All those in favor respond by saying aye. Aye. Those opposed, no. The ayes have it, and the amendment in the nature of substitute is agreed to. The question occurs on the passage of H.R. 3808, a reporting quorum being present. The question is on the motion to report the bill H.R. 3808 as amended favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no.
No.
The ayes have it, and the bill is ordered reported favorably.
Mr. Chairman,
The
I ask for a recorded vote.
record vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes aye. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Issa? Mr. Issa votes aye. Mr. King? Mr. King votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Poe? Mr. Poe votes no. Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Gowdy votes aye. Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes aye. Mr. Collins? Mr. DeSantis? Mr. DeSantis votes aye. Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. Rutherford? Mr. Rutherford votes aye. Ms. Handel? Ms. Handel votes yes. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Johnson votes no. Mr. Deutsch? Mr. Deutsch votes no. Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? Mr. Schneider votes no. Ms. Demmings? Ms. Demmings votes no.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 16 members voted aye, 14 members voted no.
The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. This concludes our business for today. Thanks to all our members for attending. Markup is adjourned.